Good morning, friends. My today's topic is: can the executive court dismiss an execution petition by treating the degree for possession as inexecutable, merely on the basis that the property has been lost to a third party, or you can say stranger? The Honorable Supreme Court said, no, it cannot be done by the execution court. And further said that if this is allowed to happen, every judgment debtor who is in possession of immovable property till the decree is passed shall hand over the possession to a third party to defeat the decree holder's right and entitlement to enjoy the fruits of litigation. And this may continue indefinitely, and no decree for immovable property can be executed. This was said by Honorable Bench of Justice B.V. Nagaratna and Honorable Justice Prashant Kumar Mishra while hearing an appeal against the decision of the Delhi High Court, who had affirmed the order of the Executive Court, holding that the degree for possession of immovable property was not executable against the judgment debtor, that was Municipal Corporation of Delhi. It was the case of Municipal Corporation of Delhi that the suit land originally leased to it by the decree holder was not under its possession, and that the same was in possession of the encroacher, who should have been identified by the decree holder. Following the appeal, the top court held that it was the duty of the executive court to issue warrant of possession for effecting physical delivery of the suit land to the decree holder. Further, if any resistance is offered by any stranger encroacher to the degree, the same has to be adjudicated upon by the executive court in accordance with rules 97 to 101 of the order 21 of the Civil Procedure Code 1908. The court said that unless the procedure is adopted, the executive court could not have closed the execution proceeding by observing that the decree is inexecutable. Coming to the facts of the case, here Ved Kumari, appellant, had leased out the suit land to the MCD in 1973 for a period of 10 years. The lease was not renewed subsequently. Thereafter, the appellant served a notice upon MCD to hand over the vacant possession of the suit land. The appellant filed a suit for recovery of possession against MCD, and decree for possession was issued in favor of the appellant. In the execution proceeding filed by the appellant seeking enforcement of the decree of possession, MCD informed the court that the suit land was not in its possession and the same had been encroached upon. The executive court, after taking into consideration the demarcation report submitted by the MCD, dismissed the execution petition on the ground that encroachers upon the suit land were not party to the suit, and therefore the decree could not be executed. Against this, the appellant filed a revision petition, which was dismissed by the Delhi High Court. The review petition filed by the appellant was also dismissed. Now, the Supreme Court analyzed the whole case and observed that executive court had found that MCD's stand at the inception of the suit was that the suit land was in MCD's possession. However, in the execution proceeding, MCD had taken a completely different stand that the suit land was under possession of encroachers. The executive court had expressed doubt as to how the MCD at the stage of execution could take an altogether different stand. It was of the view that MCD was liable to disclose as to how the possession of the suit land had passed to the third party. However, the MCD had failed to respond to the said query properly. The executive court held. The top court also noted that throughout the course of execution proceeding, no resistance was offered by any stranger encroacher to the decree. In the absence of such a resistance, the executive court had no occasion to invoke Order 21, Rule 97 to 101 at the instance of the decree holder or otherwise. Unless this procedure is adopted, the executive court could not have closed the execution proceeding by observing that decree is inexecutable. The Honorable Bench of Supreme Court held. The court referred to catena of judgments that the deal with the executive court's power and authority under Order 21 of the CPC for resolving all disputes pertaining to the execution of decree for possession obtained by decree holder. In view of the settled legal position, it was the duty of the executive court to issue grant of possession for affecting physical delivery of the suit land to the decree holder in terms of the suit scheduled property. If any resistance is offered by any stranger to the decree, the same be adjudicated upon in accordance with Rule 97 to 101 of Order 21 of the CPC. The executive court could not have dismissed the execution petition by treating the decree to be inexecutable merely on the basis that the decree holder has lost possession to third party or encroacher. If this is allowed to happen, every judgment debtor who is in possession of immovable property till the decree is passed shall hand over possession to the third party to defeat the decree holder's right and entitlement to enjoy the fruits of litigation. And this may continue indefinitely, and no decree for immovable property can be executed in this way. So the court accordingly allowed the appeal and set aside the order of the executive court and the high court. The further order was the executive court is directed to execute the decree by effecting delivery of physical vacant possession to the applicant decree holder in accordance with the provisions contained in Order 21 of the Civil Procedure Code. The case title is Shrimati Ved Kumari, dead through her legal representatives. And the citation is 2023 Live Law SC 712. This is all about the complications in execution of degrees. So there should be some amendment in the law so that the fruits of degree holder, which he has achieved through large process of civil litigation, be enjoyed by him, and the law should be changed to such an extent that everyone gets his right through proper procedure in shortest time. Thank you for watching. God bless you all.